Welcome to Ground Rules, Employment Law Over Your Coffee Break. My name's Pam Howland, and I'm here today with Jennifer Walrath and with Doug Plass. Both are attorneys with Idaho Employment Lawyers. And today we have a special guest with us, JD Houvener from Bold Patents Law. So JD, welcome to you.
Hey, thank you. Thanks for having me on. This is great.
This is so exciting. So, JD is based out of Moses Lake, Washington. He's a patent attorney. He has a book called Bold Ideas, which we have sitting here right in front of us. Congrats on that. And today he's agreed to come to our podcast to talk a little bit about some overlap we see, which involves ideas and potential inventions and creations that happen in the workplace. So we're hoping we can get some dialogue on the crossover between JD's practice and ours. But before I do that, JD, maybe tell us a little bit more about the work you perform and how the work that you do sometimes flows into what could be for us like workplace law.
Yeah, absolutely. And thanks for this opportunity. It should be a really fun chat. So at Bold Patents Law Firm, we predominantly serve individual inventors and technical founders of what will become hopefully companies. But we do also serve individuals in their capacity. Oftentimes they're moonlighting or they're dreaming on the side, and they've got an employment position, full time or part time, as they engage us. And it's one of those early questions we always ask is, hey, is this invention related to the job you're doing? Before we get started and even take your money, we need to make sure that if we end up getting a patent for you, that you're going to own it. Let's make sure we're not going to be paying for something for your boss. So that's one of those early questions we end up having. And then, of course, as our clients grow, we do have a small group, maybe 10 to 20% of our clients that become revenue generating companies and employers, and start asking questions about, hey, when I hire someone, if they're going to be inventing, what happens then? And so all that and more I'd love to talk about today.
Perfect. And we, over the last, Idaho Employment Lawyers has been around 9 years now. The whole concept of what we call keeping secrets safe has become a very large part of our firm, which I would not have really contemplated at the time we started it. But we do a fair amount of work on non-competes, non-solicitation, confidentiality breach, even trade secrets at any given time over the past 5 years. I would say we've had litigation here in Idaho in some form or fashion over trade secret misappropriation. So we like to talk about our ideas and best practices and recommendations for keeping secrets safe. And it sounds like the type of work you do is going to involve some of those same concepts, maybe a little bit deeper dive on how those issues bump up against your world on patent law. But let's talk a little bit about that, because I think any way you cut it, there's going to be some good takeaways for employers on things they should be thinking about. So maybe tell us a little bit, what type of issues you see and what type of recommendations or ideas that bump up in your practice on whether or not an employee has an entitlement to something they design on the job, and whether or not that is something the employer needs to worry about protecting, or maybe when the employee leaves, does the employee get to walk out the door with it?
That's great. Yeah. So when we have that conversation with an inventor, I like examples. So let's say it's a plumber, and they've been in the industry for 20 years. And I like this kind of client, by the way, because they're not just coming up with a harebrained idea in the shower. It's totally different from what they do day in, day out. So this plumber, he or she, let's say it's a she, she's got this really neat, valve. And she knows it doesn't exist, and she knows it's going to be really simple, right? Awesome. Uh, but she's done some testing, and she works for a multi-state plumbing franchise, and has tested it on the job, has even handed it out to some other contractors to test. And the question is, did she sign an employment agreement, right? And I always say, hey, did you come up with this on the job? Did you spend any time working on it, iterating, designing it on the job? And from just that brief, description, I'm like, yeah, maybe, did some testing, tinkering, maybe was on a call, used it on one of client's jobs, whatever it is, right? And so if it's even gray at all, that's when I'll refer them out to a business attorney or someone like you, Idaho employment lawyers, to take a look at that employment agreement. At that point, we stopped. Just so you're clear, bold patents, we stay mainly really in our lane, which is a federal practice area of U.S. patent law. We also offer trademark services. But whenever it gets sticky in terms of employment law, we know that's state related. And so we get them in touch with a local counsel to review it. And there are three main factors, and we can jump into this in a bit, that I have, from my understanding, going back to law school, and those factors that judges look at, a court would look at to weigh whether it's owned by the inventor or the employer, is if that was done on the job or not, right? How much time was spent on the job? If it was in the job scope, right, to design, come up with new products like this, and then if using employers' resources. And so those are kind of things I sort of look at to see if there's any gray on those factors. And if it's even close, like I said, I'll refer them out.
Yeah, and we frequently bump up against the whole concept of employment agreements and other employment related documents that might define scope that could be applicable in a situation like that. And so hearing you talk about that, I would say a few important takeaways for employers who might be listening is really the importance of getting local counsel when you're drafting an employment agreement and thinking through various nuances that might apply. In the plumber situation, would the employer have ever dreamt that there was going to be an invention that eventually flowed from that relationship? Maybe not. So one more thing to think about. And don't use forms you pull off of like some federal, third-party database, because it might not have the stuff you need to make it stick in Washington where you're at or in Idaho where we're at. And maybe Doug and Jen, you guys jump in on thoughts on other documents that we use that might define the scope of whether or not something falls within what an employee's doing on a day-to-day basis that, could be relevant here.
Well, I think a big one would be, in your handbook, right? So what policies do you have that talk about, either what the employee is doing, or what information that the employer considers its own and what it wants to protect. And another thing that kind of came to me when we started talking about this is that there's a threshold question here, which I guess is always here whenever we do this stuff, and that's, is this an employee at all? You brought up a plumber, and I started thinking, well, gosh, maybe that's an independent contractor. So that's definitely something you want to start with. But in terms of things that we might find in in handbooks, I mean, even in the very beginning, where the employer's talking about what it is that this business does, that could be good information. Usually, though, it would probably be in a job description or something like that. That might not be something you find in policy, but it could be something found in an offer letter to the employee, or in some job description document itself.
Yeah, Doug kind of stole my thunder a little bit. I was going to say job descriptions, but piggybacking on the job offer and Doug's comments about the independent contractor possibility, Idaho, I'll use Idaho as an example. That's where we are. It is an at-will employment state, which a lot of people say, okay, at-will employment, but if you have an employment agreement, that is different from at-will employment. And so one of the fundamental questions too is, do you want to even have an employment agreement or not? But even if you don't have it, maybe you do have like an offer letter instead, and that also still combined with your job descriptions could lay out the expectations of the role, the job, some of the duties that would help to answer the kinds of questions that JD would be asking someone who comes to him.
Yeah. JD, I bet you were chomping at the bit when you heard Doug's question about the independent contractor.
Yeah, I wonder, whether it's classified as as a independent contractor or an employee. Isn't it true that a contract that the contractor signs could obligate them to assign inventions under sort of a work for hire approach, uh, even though they're not a W-2?
Yeah, what I was thinking when I heard independent contractor was we occasionally will get somebody who calls who's like, "Well, we have a contractor, but we never really worried about getting an agreement in place. It was more of a handshake." That's just one more reason why you would want a well-crafted contract that tracks with all the things you want your independent contract agreement to do, right? Like in our world, maybe that's going to be more of a wage an hour, something that, establishes this really is a contractor and not an employee. But what you said is, I think, 100% right, is that's what you would need to do if there was some type of dispute with a contractor, is show that it was contemplated in that initial bargain you struck to get the contract arrangement lined up. Yeah. So anything else that's jumping out at you, JD? Like, how about things like trade secrets or confidentiality issues that come up in your world that might be stuff that flows into ours too?
Right? Yeah, I mean, I think there's a lot of stuff we could talk about. I mean, let's say a departing employee, that's been at a company for a number of years and has learned, the ins and outs and some know-how, some trade secret information. How are they supposed to, I guess, I was kind of think of the employee side. I know you guys represent a lot of employers, but my clients are, potentially leaving a company. How do they know what they can move forward with? And after leaving, let's say a month later, they come up with an invention. How sure are they that they aren't going to be publishing trade secret information as that application gets up? They're claiming independent invention, right? They're claiming that it's their know-how. They probably learned some of that on the job. So what issues do we have there?
And I think that's more of what should be in the handbooks. It should be in policies, right? Trade secrets can be pretty nebulous. At least here in Idaho, they can be pretty broad. They can be a customer list, and even compilations of publicly available information. We think about them as being, like Coke's recipe or something like that. But they really can be an awful lot of things. And you're right, employees might not have a clue as to what is considered protected unless it's clearly spelled out to them.
I'm curious, JD, like when you talk to people, I guess I don't know how soon in the process, employees come to you, but do you recommend that employees like ask their employer what their position is on this or engage in a dialogue?
Well, so I have one, potential, one client I'm working at now where it's close and they've looked at it, and it's one of those deals where I would feel more comfortable as their patent counsel if something was in writing, call it a waiver, right? Where the employer says, you know what, we're not going to pursue this, even if we had, even if you employee were deemed to be, have to assign this to the company, you're welcome to pursue this on your own, right? So long that it's not going to take away from what you do for us as the employer. Uh, have you written those types of, call it a waiver, call it a whatever, a rider that clarifies specifically, hey, to this invention, that this employee is welcome to moonlight, is welcome to, take this on outside of work?
I can't say that I've ever bumped up against that in that context, but I love the approach. I mean, I'm always going to advocate for some type of proactive approach as opposed to let's just take our chances and litigate, because as litigators, we see how that escalates into crazy, huge amounts of time and money. We see that more often, I would say, in the non-compete arena, where an employee might be like, I don't know, I kind of feel like I might assign something that says I can't go work somewhere else. Should I just take my chances and go, or should we try to like get a dialogue here going, knowing that I, the employee, am taking the chance that it's going to alert them to something that might trigger a lawsuit. So we see it more on that type of situation. But I agree with you. I think it's better to take a proactive, let's know what we're dealing with, rather than lay awake at night worrying about it.
Yeah. It's kind of those things like, totally separate example, but you go down to the professional ball field and you'll see kind of those, call it mom and pop, people selling, professional logo branded stuff. And there's no way they've got a real license agreement to do that. But it's sort of this de minimis level of infringement. And I say, look, well, if your goal is to stay small and hobby level and just go invent this almost for an academic purpose, probably going to be okay. But if you're going to go into commercial and you want this to go big, as soon as it gets big and there's big money there, you bet that employer is going to be wondering and asking and trying to claim ownership over it. So if you're hoping to be bold and go big, you got to make sure you're proactive and doing your diligence up front and getting the everything, I's dotted, T's crossed.
Well, I was going to add to that on the employer side. One thing we often recommend employers do as well is when an employee is leaving during your offboarding process, that's a great opportunity to remind them of what your expectations are as the employer. If they sign something that restricts what they can do once they leave, give that to them, talk about it. So also for the employer to be proactive in saying, this is what we're expecting, reminding you of what your obligations are. That's a great time to do that.
Yeah, and I was going to add another point too on the scenario you were talking about, JD, with a departing employee. How would they know whether something is potentially confidential or going to create a problem? That, I would say, in our practice is probably one of the most important things an employer can do, which is make sure you've got a good policy in place. Doug's touched on it a little bit, but I would even take it a step further and say if you're in an industry where people might be developing something, then that needs very specifically highlighted in your handbook as the type of information that you regard as being confidential and proprietary. And as an employer, we always counsel employers to have some type of confidentiality agreement signed on the front end, not just a blanket one that somebody pulled off, a place selling forms, but the more tailored it is to the specific types of info that you run across, the higher the odds that it's going to be enforceable somewhere. Our Trade Secret Act, and I haven't studied the Washington one, but I suspect it too has that language that says the only way you can really get a trade secret claim going is if you can show you took reasonable measures to maintain the secrecy. And some of that includes the very question that you posed, which is if you're not telling your employees on the front end what type of info is confidential, then how can you expect them to recognize that as something that's potentially a trade secret? So really making sure you've got some type of agreement and some type of policy in place is a very big deal.
Right, right. Yeah, I think that it's interesting this balance of, and there's kind of this balancing of non-compete, and I think the courts have got to balance, hey, this is a professional who, deserves to make a, living for their family, right? Deserves to be able to be free and find work post employment. If your policy is so broad, right, or whatever you're calling trade secret information is so broad that it really covers so much, perhaps that could limit that person's ability to have a livelihood, and so that could be their argument and say, you know what, yeah, I've been with you for 20 years. I've learned a whole lot of trade secrets. I'm going to go be a plumber and start my own company. And how would you parse that? How, as the employee, the previous employer, you see them pop up as a competitor, I think it'd be challenging, right? What would you point to? Maybe really specific things that maybe your company was privy to, right? I don't know. You tell me, what would you kind of think about?
Yeah. Well, what you said, that is frequently the defense in a confidentiality breach, fiduciary breach, trade secret misappropriation. Frequently you hear, well, that's just info that I acquired. That was, on the job. There was nothing secret about it. Um, I think as an employer, again, it goes back to how well you've defined it on the front end. Um, what kind of conversations you had, what type of efforts you took to maintain secrecy over it, even whether it's like you said, through a non-compete, which is kind of its own separate topic that we love to talk about too, or even how you're safeguarding your technology, right? Like that's another issue that we talk about a lot here is if it's something that you as an employer think is very proprietary, confidential, and secret, then just easy example, you probably shouldn't be letting your salespeople or others access it on their personal cell phones as they're doing their normal course of business on a daily basis, or else it looks like maybe it's not that secret.
Everything can't be a secret, right? As the employer. So maybe there's this sort of maintenance, if you will, of, allowing some things to become non-proprietary, every day, as long as enough time has passed, and maybe they wouldn't meet that threshold of being valuable, right, to the market anymore, or they're not, or they are readily ascertainable now to the general public. So, yeah.
Yeah, Doug and Jen, do you guys have thoughts on that? Like, yeah.
Well, I was just going to throw out there, I think if you are an organization, you have different things that are valuable to you, right? You have your employees, you have your customers, your clients, you have actual information, which, may be proprietary, maybe a trade secret, and kind of all those things can be protected in different ways, right? So, like the non-compete we've mentioned, those are legal here in Idaho, provided they meet certain standards. They can be hard to enforce, but you can have them. And that is one way you can protect some of your, assets, I'll call them. You also could have like non-solicitation and poaching type agreements. And I think kind of where we're all landing here today is really more focused on like the information and protecting taking of the information itself. I suppose with patents, there's a bit of what might be protected by a non-compete too, with like process and know-how and things like that. So what I guess all that comes down to for me is that if you are someone looking at these types of avenues for how you would protect your information, it's really sitting down, figuring out what do I have, what's valuable to me, what are the options realistically available to me to protect those? And of course, I'm talking from an employer perspective, but I think it really does merit kind of a thoughtful analysis out the front as to what makes the most sense given the nature of your business, your information, your assets, what you want to protect, what state you're in, what you can and can't do, and then go from there.
And I think in terms of kind of the nebulous, I guess, information that you were talking about a minute ago, I think the employers have to be aware that, the issue with letting employees leave the departed earn a living is a real one, and courts are very skeptical of that, and that is why there are these duration requirements in non-competes. So that if that's the kind of information that you're worried about, and you can't clearly define it in your agreements with your employees, then maybe a year and a half, it's going to be disclosed anyway. So you're going to have to take that into account in running your business. So
Yeah, I think one more thing on the patent side is I think employers should realize that if you've got information, technology, trade secret information, considering whether or not that is patentable and making a decision about pursuing patent protection or knowing that it's a risk. We're keeping this as a trade secret and you are taking a risk. I mean, by doing that, honestly, by keeping a trade secret that is patentable, you're kind of saying, hey, I'm not ready to launch this in the market now. But what you're doing is actually against the policy of the US patent system, which is we want you to share your ideas. And in exchange for sharing it with the world, we're going to give you this limited monopoly. You're just like, nah, I'm betting that no one else is going to come up with this before I do. Or we're going to keep this in our back pocket. And if someone else, another competing company, files for a patent on it, you immediately lose your trade secret, protection, if you will, because you sort of took that risk of keeping it in-house.
That's a good reminder, because I think for us, yeah, so we've again had a handful of trade secret cases that litigated, and we've grappled in Idaho. We just don't have that much case law. Hardly anything ever makes it all the way up to the Supreme Court. So you're somewhat on your own trying to understand what the statute means, and the language of it seems broad. But one of the key Idaho cases talks about a hash brown recipe. So that kind of goes along. Yeah, of course it does. That kind of goes along with the type of trade secret you're talking about, this like secret recipe, right? But in our world, we think of trade secrets as being much broader than that, things that you wouldn't necessarily patent, right? It could be your price list or your customer list, or like how much everybody's getting paid if it's in an industry where that's a competitive edge that's not easily ascertainable. So that's a good point, that there are a lot of different types of trade secrets, and all those are going to require a very different analysis.
Yeah, I wonder, I think it was maybe 5 years ago now, the federal remedy, right? The Defend Trade Secret Act was launched. And so there's now a way to get into federal court alleging federal trade secret misappropriation. Have you helped any clients through that in Idaho federal court, or has it all been state?
It's funny. We have a case right now that's just getting going. Most of our stuff has been in state. That's the first time we've had one pop up under the federal act, but most of it has been driven through state court litigation.
Yeah. Well, cool. Well, that's interesting. And, I think that's a great concept. I had never thought about to sort of, categorize types of trade secrets, right? Though, and I think it might be a wise thing for employers if they've got the time and ability to do so, to look at that. And I would love for them to be able to kind of say, hey, these are little baby chicklet patentable trade secrets, and then these are more. You have talked to the patent attorney. These are probably not patentable, but we're keeping these sort of separate from that, and just creating a process handbook to make it clear.
Yep. So I guess as we're thinking through, like as we're kind of recapping where we're at, some of the key concepts that seem to have crossover that keep popping up are the use of employment agreements, fully defining scope of employment, possibly confidentiality, job descriptions, further defining scope. Maybe you're going to have non-compete agreements, non-disclosure agreements. Anything else cross your mind, JD, as far as what you see that ends up being part of your analysis?
That we've covered a lot. That I can't think of anything specific.
Well, I think that's a good starting point for employers to think about ways that patents might impact the types of policies you need, the type of documents you need. I'm hoping, maybe there's employers out there who are listening going, I never thought of that. Maybe you're in a manufacturing industry, an engineering industry, and the whole concept of someone developing something on the job and possibly seeking to take it with them has never crossed your radar.
There's one more I just thought of. Sorry, Pam, but I'd love to bring it up. So we've talked about the departing employee. How about the onboarding employee that's bringing with them patents that they've brought, maybe even pending applications, and maybe some best practices for clarifying with that employee who owns what, and maybe even further inventions, how to properly, treat that and those separately, or if they continue to innovate, how you might, as an employer, claim ownership of those.
Yeah, great question. Jen, Doug, anybody have?
Well, what I was going to say is I don't think we've really seen that come up in our practice yet, but what we have seen that I think is similar, and you could take a similar approach in thinking through it. For example, if you do sales and maybe you're in an industry where you have your own book of business that kind of travels with you, we've seen it where someone comes in, that's part of their value add, right? To going to work at the new place is I've got people I'm bringing with me. And, we've seen it laid out in agreements where they say the stuff I bring in is mine. Anything that I develop kind of while I'm here working for you, where I'm using company assets, right? We're kind of seeing a theme here using what the employer is bringing to the table to help with building that up or developing new leads. That will stay here. But whatever I brought in with me when I go goes with me when I leave. And I'm sure it's not that simple always, right? There's going to be things at the edges where you have to work through. But I would say as long as that's kind of an issue that's brought up at the beginning, going back to kind of being proactive, you can work through it, talk through it, I think figure out a way to make sure everyone kind of understands out the gate what the intention is and what that looks like, get it documented in a way that makes sense, and then hopefully that will help everyone down the road, if that person leaves, know what will happen at that point in time.
And that makes me think about just this whole idea of, okay, they bring this information with this. Maybe they're patented, maybe it's not, but they bring some invention with them, and that invention is used at the employer. So maybe JD, talk a little bit about the concept of assignment of patents and whether or not that might be something that employers and employees might want to pursue in that particular situation.
Right. Yeah, it's assignment is transferring ownership. It's kind of a fancy term, but there is a process for recording assignments at the patent office, and it is specific because each named inventor has the full right to exploit the ability to make, use, sell, or import that invention into the area, the jurisdiction that the patent was given for. And so if there's several named inventors, each one of those has to have a separate signature line. And we've had it where one of the inventors decides to assign their rights to a company, the other does not, which is quite interesting. The inventors break up, right? The business partners do, and so that can get quite interesting. But keeping the scenario simple, in an employment agreement, I think most employment agreements would, as part of it, hey, any invention you come up with while on the job is is subject to assigning to the company, along those lines, right? And so there's this concept of, as the inventor invents it, yes, they're the owner, they're the inventor, and if they invented it as one of those on the job inventions, then they have an obligation to assign it, to transfer that invention ownership to the employer, and the timing of that can be important, and so that's why the employer will be wise of them to have a process for invention disclosure. Hey, what have you come up with? So let's hear it, and have that maybe by an in-house or an external, counsel to review to see whether it'll be worth it to file. And of course, that'll be up to the executive suite or the owner of that company to decide whether they're going to file for patent protection or not. That has come up with our clients where the employers decided not to pursue a patent, and they said, "Hey, employee, you're free to commercialize this on your own." And I've just encouraged them to get that in writing. Of course, the employer decides not to move forward, not to invest money into a certain idea. Anyway, I don't mean to keep going, but long story is that assignment is that transfer of ownership.
Yeah, that I love that, because what, maybe one final takeaway for employers here is that's one more reason to use checklists, to think through things on a case-by-case basis. I was just thinking about how many employers have employment agreements, that probably don't have an assignment clause in it, right? And maybe what every employer should do instead is have this checklist as they're getting ready to put an employment agreement in place where they're thinking through some of these issues that relate to keeping secrets safe. Do we need some type of non-compete provision? Do we need some type of non-solicitation provision? Should we have an assignment clause in here? Have we got the right state law stuff based on whichever state this is being executed in? I think that's important. Checklists, we're big fans of those. There's no way everybody can remember everything they need to without them. And even back on your prior question, where you were talking about what about a new employee who comes to the business who might already have a patent pending or some type of confidential info that they're bringing with them. I was thinking about an onboarding checklist there too. That's always a great question to ask in onboarding as people are, potentially, coming in the door here is, are you subject to any other agreements? Because we see that more in the non-solicitation, non-compete. But asking about that in an onboarding situation would be a great way to find that out too. Okay, I think that's it for today. That's it for ground rules, employment law over your coffee break. A couple thoughts as we head out the door. Our book, Law for Leaders, does not talk about patent law. You should look at JD's book for all things patent law. His is called Bold Ideas, JD Houvener. Our book doesn't talk about that, but Doug wrote the chapter on non-competes and non-solicitation and confidentiality, which is in there. So check that out. JD, thanks again for coming. Greatly appreciate your time. That was a great conversation about other issues outside of what we do that employers should be thinking about.
Yeah, it was a lot of fun. Thank you for having me on your show.
Great. Thanks, everyone. We'll see you next time on Ground Rules.
Ground Rules hosts and guests are not providing legal advice in this podcast. Do not act upon any of the information discussed in this podcast without first consulting a licensed attorney in your jurisdiction.